Hi there. Welcome to the final video of Module 4 and Module D, and that's video 3 for those keeping track. And I just have kind of a few main points to go over with civil liberties, and they're mostly conceptual. And again, what I try to do with a lot of these lectures is I'm just trying to give an overview. I'm not able to really capture the entire chapter within this lecture, but I'm hoping to give you some of the main ideas that you'll need in any civil liberties course if you decide to go on with this. But then also, anything you'll need in terms of preparation for, of course, the module exam or the final essay if you end up writing something about civil liberties. So what are civil liberties? Civil liberties are not the same thing as civil rights. We'll cover civil rights in another unit, but civil liberties are not the same thing because they're kind of our protections against government. There are freedoms. There are the things that we are free to do without government restriction, or there are protections from the limits of how much government can encroach upon our lives and ourselves. And so there are protection against government, and whereas civil rights are our right to kind of freely participate in the civil life of a republic or a system of government. So the way that our civil liberties have kind of arrived for us before we were born here in the U.S. or arrived here via immigration to the U.S. Is they were formed by a lot of different conflicts, and some of them even conflicts before the U.S. was born. One that I want to start off with is the English Glorious Revolution of 1688. And without getting into the history, though it is kind of a very interesting history, I wouldn't call it glorious, but it was called glorious because there was no battle. There was no bloodshed. There was a king that left, and then a new king arrived, and that was glorious. So there was no civil war. So that was the Glorious Revolution. But because of the Glorious Revolution, the part of what happened is that Parliament really, ironically in a way, reasserted itself. It kind of kicked out almost the last king and chose a new one. From suitable candidates, of course, right? Had to be of royal blood. It was actually the nephew-in-law the son-in-law? I think actually the son-in-law of that king. At any rate, the English Bill of Rights, they did what the U.S. did later on when they were kicking out King George. The English kind of wrote this law, the English Bill of Rights, in 1689, about a year after the Glorious Revolution happened. And it was, and I'll just take it from the title, an act declaring the rights and liberties of the subject and settling the succession of the crown. So the rights and liberties of the subject, meaning subjects of the king, and those are the people and Parliament. Parliament is, as I think I've mentioned before here, Parliament is their legislature, it's their Congress, and Parliament is where they get together to talk. Historically got together to talk about issues, but they had grown more institutionally powerful, and they had grown to be the kind of primary process body that was able to pass laws that were collecting as well as taxes as well as spending revenue. In other words, they made the laws, and they were the ones who decided how to collect money and spend it. And the last king had done that, had really tried to go around them quite a bit. The last few kings had gone around them quite a bit. And there had been an English Civil War before. I don't want to say they avoided civil war altogether. They had a really big one about 40 years before this. And Parliament actually won that war against the king. And I'm oversimplifying matters, but the Parliament was made up of kind of new money. They were the merchants. They were the people who were not traditionally royal, but a lot of them came to have royal titles because they were basically able to buy them. But this is a very long process. And one of the things they did in this bill was they kind of listed the offenses the last king had committed against them. And I want to read a couple of them because I think you'll find them very familiar. They insulted the parliament in the various ways. And one of the ways was by raising and keeping a standing army within this kingdom in time of peace without consent of parliament and quartering soldiers contrary to law. And let's see. And whereas of late years, partial, corrupt, and unqualified persons have been returned and served on juries and trials, and particularly diverse jurors in trials for high treason, which were not freeholders, and that is, people who own property who are not royal. And excessive bail hath been required of persons committed in criminal cases to elude the benefit of the laws made for the liberty of the subjects. And excessive fines have been imposed, and illegal and cruel punishments inflicted, and several grants and promises made of fines and forfeitures before any conviction or judgment against the persons on whom the same were to be levied. And so it should sound even more familiar because they said, according to these offenses, we have drawn up a list of rights that Parliament has and the people have. Let's see. That it is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal. So, and let me say one more. That the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. So, First Amendment to the United States Constitution and the Bill of Rights. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Well, there's more about that. Or abridging the freedom of speech or of the press or of the right to people peaceably to assemble and to petition the government for redress of grievances. So all of that language is lifted right from the English Bill of Rights. And one of the things they talk about quite a bit in here is the difference between Protestants and Catholics because they were Protestant. Parliament was Protestant. The last king was basically Catholic, and the new king was going to be Protestant as well. And they want to make sure all kings are Protestant, and they didn't persecute Protestants in recognition of Catholic authority. What's another one? Raising or keeping a standing army. We kind of covered that one. And the redress of all grievances for the amending, strengthening, and preserving the laws Parliament ought to be held frequently. And that excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So, Amendment 8 to the U.S. Bill of Rights. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. So the U.S. Bill of Rights meet the English Bill of Rights. I mean, it was the reason for the name Bill of Rights. They were the first 10 amendments to the U.S. Constitution. And there are many more of these amendments, as I know you have access to and have heard before. So I won't list them here. You all know them. And the right to bear arms for militia was also really taken from the English Bill of Rights as well. So all of that stuff was part of their existing political culture that the U.S. was sort of migrating en masse from the Atlantic, from the other side of the Atlantic. And so all of the things we understand as criminal rights that are due process rights or that are also to do with kind of our freedoms against the government and also our freedom to, worship really just came from this political battle that the English had 100 years prior to even the U.S. Constitution being adopted. So today, the reason why we have religious freedom in the U.S., or at least relative religious freedom, is because there was this conflict between Protestants and Catholics, 350 years ago. And for example, so just goes to show you, history really can be very powerful to know about and learn about. but it also puts into context a little bit of, when we exalt the Constitution as this kind of, brand new document that was genius. A lot of it was just taken. A lot of it was just the result of other conflicts that they just kind of lifted from, and I would borderline plagiarized from other sources. And this didn't really include judicial review, though, and judicial review was a relatively new idea, because they did not want either Parliament or the monarchy to be, or the executive in the case of the U.S., to be dominant over the other to the detriment of kind of all of these liberties. They wanted to have a guardian of these liberties besides just Congress or the president, and that's why they created a Supreme Court. And so this Supreme Court, as we've talked about in the past, it's been their job to say what the law is, and therefore how the laws are interpreted. And until the 1860s, after the Civil War, when the North was imposing conditions on the South for readmission to the Union, they said that you have to ratify these three amendments, and they very simply say, number one, the 13th Amendment will say that slavery and involuntary servitude are abolished and unconstitutional and illegal from here on out. That's the big one. The 14th Amendment, I'll just say very quickly, one is that the equal protection of the laws is gonna extend to all people who are now free, who formerly were enslaved, and all of that same population should also, as well as the rest of the United States, should have due process of laws. And they already had a due process clause in the Constitution, in the Bill of Rights, but this one was for the states. So no state shall deny people the due process of law. That's a very important point I'll come back to. And then the 15th Amendment said that, you can't restrict people's voting rights based on their race or national origin and or religion, I think. And so the Due Process Clause is the one I want to talk about, because the Due Process Clause is what allowed all of these rights in the Bill of Rights, in the U.S. Bill of Rights, to, for the first time, they were applied to the states. Up until that time, there had even been one case where I believe Barron versus Baltimore, that they could have applied all of these federal government kind of guaranteed Bill of Rights to the states, but they chose not to. And after that began a process that is kind of a big word that I don't like to test people on, but it's called selective incorporation. It just means that it's silly, really, selective incorporation, because what it does is it makes it so that every time a law is passed, or a case comes to the court where there is a conflict between a citizen who says his rights have been infringed by a state, his federal rights have been infringed by a state, they have to hear that case and rule on it, and for the first time say that this particular right, because it's never reached the Supreme Court before, we